Brought to you from the state of Connecticut, capital city of Hartford, this is a Department of Developmental Services production. Today's presentation, Guardianship of an Adult with Intellectual Disability in Connecticut.
Good afternoon. My name is Sandy Tranfini, and I'm an attorney with Connecticut Legal Services in the Waterbury office. Today we're going to present a presentation on guardianship of an adult with intellectual disability in Connecticut. And this presentation is made possible by a grant from the Connecticut Council on Developmental Disabilities. With me is Jen Carroll. She's a parent of an adult with intellectual disability. I've asked Jen to ask questions as we go through the presentation, questions that might be pertinent for other parents to help them through the process of achieving guardianship with their child. So, the first thing I'd like to talk about is legal capacity. In Connecticut, the legal age of majority is 18 years old. Often I hear a misnomer. People will say that someone is their own guardian. That's a misnomer. People are not their own guardian. At 18, you're simply an adult with legal capacity. So the only way to divest an individual of capacity is through a judicial finding of incapacity. In Connecticut, this is done by petition to a probate court. You have a hearing following the application to the court. The hearing has notice, and the individual has an opportunity to be heard. The respondent is entitled to be present and to be represented by an attorney.
Sandy, for families, for parents and family members who will be going through this process for the first time, it's something very new. So I just have a few questions for you about the beginning of the process.
Okay.
In terms of providing notice to the individual, how does that happen?
Why don't you tell me how it happened for your family?
Sure. So we were given paperwork by the probate court in our town, and we completed that paperwork, and then they told us that a marshal from the town would come to our home to serve our son his papers, which was surprising and new and something we had never experienced before. So a few days later, the marshal came to our home and we let him in, and he actually physically handed an envelope to our son.
That's called service. So your son was served with the application that a guardianship was being sought on his behalf at the probate court.
And that will be the same for every individual?
That would be the same for everyone.
Okay, just for clarification, who is the respondent? Is the respondent?
The respondent is your son, is the person for whom the guardianship is being established.
Great. And he will receive an attorney, or is it my responsibility to get an attorney for him?
The court will appoint an attorney to represent your son. Certainly if he has his own attorney, he's entitled to his own attorney. But if he does not have his own attorney, the court will appoint one. It's usually some of the young town attorneys or someone nearby in one of the big firms in town.
Okay. And do my husband and I need to get an attorney for ourselves?
Not ordinarily. Certainly if you have a family attorney, it might be something that you'd go and ask if they would be available for representation. It's not completely necessary. Usually these proceedings are not adversarial.
That's good to know. In terms of the process itself, our son has significant intellectual limitations. Is it something that I should worry about, that he won't understand this process?
That's why he's represented by counsel. Counsel has the obligation to have a framework of what he does understand and let the court know what his boundaries are and what his level of understanding is.
Okay, that's great. Is there anything that we can prepare ahead of time in advance of his 18th birthday just to make the process go more smoothly?
Certainly, every family has to think about their minor children. You can establish a trust, you can meet with estate planning people to provide for all your children in the event there's an accident or something happens to either your husband or yourself. That would be no different from anyone, a child with a disability or not. In addition, there are, of course, with kids with intellectual disability, you have special education issues. That's not a part of this presentation, but that certainly is something else to consider.
Okay, and just one last question on this part. Getting started with something new, sometimes we worry about what it will be like through the process. Is there any reason to fear that this will be an adversarial process between us and the court or the attorneys or anything?
It's extremely rare at this point for a guardianship to be adversarial. Certainly I have seen adversarial guardianships. Usually when someone is very high functioning and disagrees with their parent or with the person bringing the petition as to the level of the guardianship, that does occur. But overall, you know your child and your child trusts you. I don't see any reason to fear the process.
Good news. Thanks.
So, Connecticut probate courts are a separate system from the Superior Court. They're our oldest court system. You should know that they've recently been consolidated. There used to be, I think, like 130. There was quite a few probate courts, but they have been consolidated and changed. Judges are always elected, and they're elected by town. Judges must now be lawyers. And it is a statutory court, so the powers of the court are confirmed only by statute. Unlike Superior Court, where you'll have case law precedent, this is a statutory-only court. The law is in the Connecticut General Statutes. It's all throughout the statutes in the probate court section, and it's all very clear statutory conferment.
Great.
So a judge may appoint a guardian of the person with intellectual disability for a person with intellectual disability after a finding of incapacity. So the judge has to find that the person has incapacity, and that is defined by statute. It's following a hearing, and there's notice to the respondent. And I have on the handout with the PowerPoint, there are statutory references. So it's Connecticut General Statute Section 45A 669 through 684 generally for the guardianship.
Sandy, I know there's going to be paperwork for this process for everyone. Since we're not yet Jamie's guardians, is that paperwork that we have to have somebody fill out on his behalf, the attorney, or can we fill out the initial paperwork for him?
The petition can be filled out by you. There is a fee with the petition. It can be filled out by you. It's a fairly simple process. Certainly there are clerks available at most probate courts. I don't know, it kind of varies how much they're able to help you with the petition. Certainly you're always entitled to seek an attorney for help, but I found that the petition is fairly straightforward for parents.
Great. And once that attorney is appointed by the court to our child, will he have to meet with that attorney? What will the process be for that?
The attorney is required to meet with their client, and they have to meet. It's best they meet with them individually without the parents present, and talk a little bit with the client, begin to understand perhaps his level of capacity, begin to understand the home situation and what resources are available to the individual through DDS and through the family and through any other sources, to help just to help clarify with the court what the degree and level of the guardianship is needed.
And it will be okay if it's more of a one-sided conversation, if our son is nonverbal and not able to answer, that will just be more information?
Of course.
Okay.
Of course, and that's pretty standard.
Great.
So nothing to worry about.
Thanks.
Okay, so the probate court, there are 5 areas of appointment in our present Connecticut law for guardianship. And the 5 areas, the first 4 are very specific. The first one is to assure and consent to a place of abode outside the natural family home. The second one is to consent to specifically designed educational, vocational, or behavior programs. And then there's to consent to release of clinical records and photographs. The fourth one is to assure and consent to routine, elective, and emergency medical and dental care. And the final one is a specific limited power, which is really kind of like a catch-all, where the judge can appoint a guardian for specific things to assure and consent to services necessary to develop or regain to the maximum extent possible the respondent's capacity to meet essential requirements. So If you have all 5 powers granted, it's called a plenary guardianship. Less than all 5 powers is a limited guardianship. And for both plenary and limited, it's very important that the least restrictive appointment should always be made. It's important to understand that this is really a taking away of individual power. You really have to take into account the natural environmental safeguards available to the respondent as well as mental capacity. So I've only ever seen these appointments be overly broad. I like to see them least restrictive. Less is better. You can always go back and ask for more to the probate court at a later date. But really, a less restrictive appointment should always be made.
So will it be our son's attorney who makes the decision between plenary and limited guardianship?
Your son's attorney will probably make a recommendation to the court, but it really is up to the judge as to how big and how broad the guardianship should be.
Okay.
So it's important that if the attorney doesn't seem to be demonstrating for the court the correct capacity of your child, that you step in and take over that role and make sure that the judge has an understanding of what your son or daughter's capacity is.
And can you talk a little bit about the benefits of limited guardianship?
It's a very difficult and subtle difference between limited and plenary. I can tell you a story it was very important to me, and it happened to me when I was first an attorney many years ago. I was present in a medical setting for a person who had a limited guardian, and the doctor heard guardian, but when they heard that word limited, the gaze of the doctor turned from the mom to the person. And in that moment, I understood the difference. To me, it's a very subtle difference, and really what it's doing is it's just giving a bit more regard to the person. So I like to see limited relationships wherever possible. And remember, it's not totally capacity. It's really environmental also. So if the environment is such that some of these powers are fine, are being conferred without a guardianship, then maybe a guardianship is not needed for that area.
I understand. With our child, Sandy, I think one of the concerns we have is that it's hard for him to make decisions on his own, but we don't want to limit his independence at all, and we want to ensure that our other children or family members who might become standby guardians or might be part of the process are included in the decision making. Does that happen?
It happens, and it should happen. I think people have to remember that when you are a plenary guardian for your child, you might not be there forever. And it's very difficult once a plenary guardianship is established to have it go back to limited. It does happen, but it's difficult. So if you don't have a really good standby person, usually these guardianships will end up with a town attorney or with a relative stranger to your child. So you really need to think of not today, but really years from today, and how that guardianship is going to be established and be maintained. A standby plenary or a standby limited guardian is a second person. The second person may be appointed in the event the plenary or limited guardian of the person dies, becomes incapable, or renounces the guardianship. And you should, when you're initially establishing your guardianship, you should take into account who the standby might be.
Sandy, that's I'm glad that you brought that up, because we do have 3 other children, one of which is already over the age of 18. So we're planning on making her a standby guardian for her brother. In the process of years passing, his other 2 sisters will become standby guardians as well. And I wonder, as the years go on and Jamie's sisters become his guardians at some point, if my husband and I cannot, are there built-in supports to the guardians and the standby guardians as they become guardians, so that they can have a complete understanding of the process and the support of the probate court in that role?
I don't think there's really built-in supports in the state. There probably should be better ones. But I think that certainly bringing the standby people on board as much as possible early on is a real, it's a real way to ensure that process is going to be completed in a reasonable way. I think that it's something that everyone really should think about, and not enough people do. But certainly guardianship is not a stagnant thing. Circumstances can always change, and people have to be cognizant of that. So special regard has to be thought of the future. And in that regard, I have also seen something that's available in our court called temporary limited guardianships. We see these less as the years go on, but certainly it has been common in Connecticut that folks can really go through life and never really have a guardianship established, and then all of a sudden they need a medical procedure or something that's relatively urgent. And so you can sort of shortchange the process a bit and get a temporary limited guardianship. If a person needs elective surgical, medical, or dental procedures or treatment involving the use of general anesthesia, and by reason of the severity of the intellectual disability is unable to give informed consent, a temporary limited guardianship can be established. When I encounter these situations, I urge the people that after that process is finished and that surgery or medical procedure is finished, that they explore a more permanent relationship. It just makes sense to do that.
Yeah, that makes sense.
So there are a lot of protections. So in Connecticut, there are certain things that a guardian cannot do, and these are in the statute, and they are for the protection of the individual. A guardian cannot cause the individual to be admitted to any institution for treatment of the mentally ill. That's accomplished in a separate statute, but it's not something that a guardian can do. Or admitted to any training school or other facility providing for the care and training of persons with intellectual disability if there is a conflict concerning such admission between the guardian and the person with intellectual disability or next of kin.
Sandy, I just want to ask, do those protections apply both to limited guardianship and plenary guardianship?
Yes, to every guardianship, and also to temporary.
Okay.
You cannot consent to sterilization or to psychosurgery. You cannot consent to the termination of a person's parental rights. You cannot consent to the performance of any experimental biomedical or behavioral medical procedure or experiment. Of course, there are some exceptions if that's for the health of the person. You cannot admit the person to any residential facility operated by an organization by whom such guardian is employed. You cannot prohibit the marriage or divorce of the person, and you cannot consent to an abortion or removal of a body organ. So there are quite a few. Other things that are protections. A guardianship is not a conservator of the estate or person. A conservator of the estate has to do with the financial concerns of a person. This is usually done where there's an estate with money and an accounting procedure and regular review of the conservatorships are done. It's a separate statutory area. The guardian has no authority to handle financial matters or obligations of the person. And a person in Connecticut can have both a guardian and a conservator of the estate. The conservator would handle the financial affairs of the person.
So I think around 18 is the same age where individuals might start to seek support from SSI funding. And in our situation, and I'm sure situations like ours, somebody had to be named the representative payee.
Correct.
Would it be important to explain the difference between representative payee?
Yes. A representative payee is not a state thing. It's done through the SSI or through Social Security, and Social Security is the one who names you representative payee. It's separate from conservatorship of the estate, which would be a similar process in Connecticut, would be a Connecticut thing that a probate judge would establish. But you can be a representative payee by applying to Social Security or to the SSI program, and that program would appoint you representative payee. So it's different.
That's helpful. It is confusing sometimes.
It is confusing. You have some reporting requirements as a guardian. You're required to file annual reports, and the court is required to review the guardianship every 3 years. And on the materials that are going to be shown with this tape, there is a form. I put the website. honestly, if you Google Connecticut Judicial Branch, there is a whole probate area under that that website, and it's very helpful with all of the forms and all the reporting requirements.
One of the things that I noticed when I did look that form up was that it's a legal length paper. I don't have legal length paper at home, and I wouldn't know what to do with my printer to set that up. So I called the probate court, and they were very happy to send me my annual reports. They sent me a couple of years worth, so hopefully other probate courts will do that.
I believe that that's now being changed, and that you can print it out on regular paper.
Oh, you can? Oh, that's good to know.
I think so.
And just one more question. In terms of the review every 3 years, will the entire process be done all over again every 3 years?
It's quite an easier process. The lawyer does have to go out and meet again with the person and give a recommendation to the judge either to have a hearing or not to have a hearing. If the status is the same, it's likely that your report, DDS's report, and the lawyer's report will all say no hearing required, and a new decree will be established. If there is a change in circumstances, perhaps the guardianship, the parameters should change, or something's happened where the guardian's no longer available, a hearing will be necessary. Whenever there's a change in the tenors of the guardianship, there will be a hearing required.
Okay.
So just a few last things. Remember, least restrictive. A guardianship is not necessary for every person in Connecticut with intellectual disability. Consideration must be given to the least restrictive method of accomplishing appropriate decision-making, including the person's capacity and natural environmental considerations. That is, family, friends, living situations, the things that surround the person that enable them not to have a full guardianship. And of course, we always look at the person's level of disability. The burden of proof to appoint a guardian, the court must find by clear and convincing evidence, and that's a pretty high standard burden of proof, that the respondent is totally or partially unable to meet essential requirements for his or her physical health or safety, and totally or partially unable to make informed decisions about matters relating to his or her care. A guardian can be removed after appointment. The determining factor is the best interests of the person, and that again is done through probate court. Okay, so that's our presentation, and Jen, do you have any other questions?
I don't have any questions. I just have a comment to make, and I thought maybe you could give me your feedback. For my husband and for myself, when we started this process, it came after many, many years of special education and the development of as much independence as possible for our child. And the realization that the process of guardianship and removing our son's independence, it was really a poignant time and an emotional time that we weren't really expecting to feel the way that we felt when the process started. And I just thought, do you feel that when you work with parents going through this process, it's important that they understand that this is not a failure on their part, but a beginning of a new way for them to support their child?
I'm really glad you brought that up. I've done many hundreds of these over the years, and I feel that it is a very poignant time for the families. It's a difficult time because the child is now an adult, and you really have different concerns, and you're starting a new chapter in life. And I think the way you put it was perfect, that you have to really believe that this is going forward, and what you're doing, just like we all do with all our children, is you're trying to find an environment that best suits your child and what that environment entails. And in your home, that would entail that you take on the role of a guardian. And I think that's wonderful. It's the best for your child and for your family. So thank you.
Thank you very much.
Take care.
recorded at the Department of Developmental Services Production Studio in HD.